Okay, boys and girls, New York is out. Came out about an hour ago. I am getting through it as fast as I can. There are a lot of takeaways here. Um, and so most people thought I'd be drinking Jack Daniels by now, but I have to go out to the gun club and run a bulldozer and finish a parking lot ahead of tonight's meeting. So uh, no liquor till later. But we will be celebrating profusely later on tonight. So let's get through a couple of things here. First question I'm going to get is what happened? We won. Uh, Hands down, the Second Amendment applies to carrying a handgun outside the home. They specifically used the word handgun. So open carry rifles and all that stuff, that can be regulated. There's a couple other takeaways. Does this impact Illinois? Yes. These are my opinions. My opinion is that they go down to page 30. There's footnote number 9, and they talk about excessive weights and stuff. I'll get to that in a minute. But yes, I think Illinois has problems on the horizon. The biggest one is that if this is a right where people are entitled to carry a handgun outside the home for self-defense, you can't limit it to Illinois residents, and those are just 3 or 4 states, because I think that that standard, which implicates our mental health standard, is on the chopping block. It doesn't work. I also think that's going to cause a problem that you can't make them, well, they have to get an Illinois license. So you would have to get a New York license, an Illinois license, a New Jersey license, a Hawaii license, a California license, forcing people to spend thousands and thousands of dollars in specific training requirements. You have to take the Illinois specific course. You have to take the California course, the New Jersey course, and those impediments put roadblocks up to the right. I think those are going to be problematic. I think that clearly what's unique about this is that all of the 6 judges in the majority, so Thomas wrote the opinion, just as I called it, and just like I said, the chief judge talked about using Heller. That is replete throughout this. I think if you go back to Heller in page 63, I think that is the standard to be pushed through the courts. They throw out the 2-part test that the Seventh Circuit originated in Ezell, and they said it had, in that 2-step process, it had 1 step too many. Another big thing there, they flip the burden of proof. The burden of proof is not on us to sit there and say that this falls within the Second Amendment. It is the burden of the government to say this falls outside the Second Amendment. So there's all that kind of stuff. So the mental health stuff is implicated in our non-resident stuff, carry law, because they say that, Illinois has this weird thing, if you've been admitted to any sort of mental health institution. Not that there's been a finding or a determination, but you check yourself in, hey, I just want to get checked out. And the shrink says, no, you're fine. Lay off the sauce, go on a vacation, whatever. But the fact that you check yourself in and you're an overnight there, that's enough in Illinois. You lose your FOID card. No mas. I think that's problematic. There's no finding and other stuff. So that's one thing. I think the non-resident stuff, problematic. I think that the Ellie objection stuff and the murder board that they have there, I think that is soon to be history, because that turns it into not objective standards, which the chief judge and Kavanaugh specifically call out, but that makes it subjective, because 2 individuals in 2 different counties with the exact same arrest record, this one can have a sheriff that objects, this one doesn't, this guy's denied, this guy's not. That's a problem. Tom Dart, you screwed up the system, you've played this game for 10 years, and now it's going to come and bite you in the ass. No ifs, ands, or buts about it. I think Illinois' training requirements could be on the chopping block. I think 16 hours just might be a little excessive. I think our fees, the chief in a concurring opinion says they can require fingerprints. They can require some training and stuff like that. But I think that but they all make the case that when it gets to be too excessive. So a couple of things. Kavanaugh and the Chief wrote a concurring opinion. Alito wrote a concurring opinion. Amy Coney Barrett wrote a concurring opinion. They all agreed with the decision in full. So you have a hard 6-3 majority in this opinion. The governor of New York and the mayor of New York City are going to be crying in their beer tonight. So we will drink those liberal tears to excess and enjoy and revel in it. So it's unique in that way. Kavanaugh and the Chief talk about the 43 states that are shall issue. Does not throw cold water on there, but it does throw cold water on licensing regimes that are excessive. They talk about a license in order to exercise a right in the public square, carrying a gun out in public. They don't talk about, I think, pistol permits in various states and the stuff of where you have to have a FOID card in order to have a gun in your own home. I think those are on the chopping block. I think that asking government permission to just exercise the right, not even just carry outside the home, and they draw a line on carrying outside the home. I think they talk about that. And it's what I said in my previous video, that I thought that it was, that the court would probably say having a license is knowing that these are good law-abiding folks is one thing. I think the other side will try to seize on that with the FOID card. So you got that. Let's read the opening paragraph from Justice Thomas and the majority of the court. District of Columbia v. Heller and McDonald v. Chicago, we recognize that the Second and 14th Amendments protect the right of an ordinary law-abiding citizen to possess a handgun in the home for self-defense. In this case, petitioners or respondents agree that the ordinary law-abiding citizens have a similar right to carry handguns publicly for their self-defense. We too agree and now hold, consistent with Heller and McDonald, the Second and 14th Amendments protect an individual's right to carry a handgun for self-defense outside the home. Period. So you have an inalienable right to be able to carry a handgun outside the home, albeit some regulations, but that's it. This in-the-home crap that we have heard for however many years that Heller was limited to handguns in the home. Now, I'm not particularly thrilled with this enumeration of handguns for outside the home, but I understand it. And so that is big. The other thing is they throw out the two-part test. And let me see if I can find that here. Let's see. So, since Heller and McDonald, the courts of appeals have developed a two-step framework for analyzing Second Amendment challenges that combines history with means and scrutiny. The court rejects that two-part approach as having one step too many. Step one is broadly consistent with Heller, which demands the test rooted in the Second Amendment's text as informed by history. But Heller and McDonald do not support a second step that applies means and scrutiny in the Second Amendment context. Heller's methodology centered around the constitutional text and history. It did not invoke any means and test such as strict or intermediate scrutiny, and has expressly rejected interest balancing inquiry akin to intermediate scrutiny. We're at a minimum close to strict scrutiny, but what I said about page 63 of the Heller opinion holds. We know of no other enumerated right subject to a freestanding interest balancing approach. The very enumeration of that right takes out of the hands of government, even the third branch of government, to decide whether the right is really worth insisting upon. That is the test. That is it. The other side can bring up mass shootings, and it's funny that Justice Breyer does so in dissent, and Justice Alito just rakes him over the coals for that, and points out that the Buffalo shooting was in New York with very strict gun control laws. Other things. In the concurring opinion, the Chief and Kavanaugh cites the favorite part of Heller that the anti-gunners quote about it's not an unlimited right to carry any weapon. They're right. The court said, if there's going to be regulations on rifles and shotguns and things like that for carriage outside the home, that's permissible. But they talk about Miller. They talk about in common use. Well, the ATF just recently, in their proposed regulations, cited the AR-15 as one of the most common semi-automatic rifles around. They just threw a bucket of cold water on semi-auto bans, and I think that will conversely move over to magazine bans and the like. In here, let me see if I can find it here real quick as I look at some of this. So they talk about, they mention the Sixth Amendment in here. They mention it 3 times. On towards the end, page 62 and 63, the constitutional right to bear arms in public for self-defense is not a second-class right, subject to an entirely different body of rules than other Bill of Rights guarantees. We know of no other constitutional right that as an individual may exercise only after demonstrating to a government officers some special need. That is not how the First Amendment works when it comes to unpopular speech or the free exercise of religion. It is not how the Sixth Amendment works when it comes to a defendant's right to confront the witness against them. It is not how the Second Amendment works when it comes to the public carry for self-defense. The Sixth Amendment is implicated, which implicates red flag laws, that you have a right to confront your accuser. And I think that this is on the front side, not on the back side. So, and I think this section here implicates the FOID card because you have to demonstrate to a government official you get to exercise your right. I think FTIP background checks, legit. I think the court will sanction those. I think sitting here and saying you have to get a special permit prior to, and they talk about long waits and stuff like that. So let me get back to page 30 here, and I'll read that footnote before I sign off and run out to club to get some diesel therapy and get the place dressed up for today. So footnote number 9. Bottom of page 30. To be clear, nothing in our analysis should be interpreted to suggest the unconstitutionality of 43 states shall issue licensing regimes, under which, quote, a general desire for self-defense is sufficient to obtain a permit, end quote. Because these licensing regimes do not require applicants to show an atypical need for armed self-defense, they do not necessarily prevent law-abiding responsible citizens from exercising their Second Amendment right to public carry. Rather, it appears that these shall issue regimes, which often require applicants to undergo a background check or pass a firearm safety course, are designed to ensure only that those bearing arms in the jurisdiction are in fact law-abiding responsible citizens, and that they likewise appear to contain only narrow, objective, and definite standards guiding licensing officials, rather than requiring the appraisal of facts, the exercise of judgment, and the formation of opinion. Features that typify proper cause standards like New York. That said, because any permitting scheme can be put towards abusive ends, we do not rule out constitutional challenges to shall issue regimes where, for example, lengthy wait times and processing license applications or exorbitant fees denied ordinary citizens their right to public carry. End of footnote. So there they talk about lengthy wait times, processing fees, and they talk about these objective standards. What I call the murder board. The LE objections are squarely on the chopping block, and as implemented by Illinois, I believe are unconstitutional. Turn it into a May issuing regime, and that's it. So, yeah, I think there's a lot to unpack here. I'm going to sign off now so I can get going. I'll have some more tomorrow. Not going to be later tonight, and I'll do some other stuff with some clips and all that stuff. But guys, we won, and we won pretty big today. And the anti-gunners, they got their work cut out for them. They really do. It would not surprise me if we see a special session on guns here in Illinois, but we'll see what happens. So that's it, guys. Signing off for now. See ya.